All right, thank you so much, everybody, for being here. Welcome to the Indian Defense Research Association's April meeting, call, webinar. Very, very happy to have everybody here. Happy to have a nice group of folks to join us. I'll start with introducing a little bit of a reminder, sort of who we are at IDRA, and then I'll pass it to our speakers to present for today. So I am Stephen Goldmeyer. I'm the IDRA board president. I've been involved with IDRA for a while. I'm very happy to see a couple of our board members here helping with the call. And in fact, two of them are presenting today. IDRA is IDRA rhymes with Hydra, I always say, which I stole from Janet Moore, one of our founders, which connotes an entity that is many-headed, fierce, and hard to kill. We're an interdisciplinary virtual community of practitioners, researchers, funders, policy analysts, etc., who care about using data to improve public defense. And in the interest of doing that, we put together these monthly meetings, calls, where we have members of our community present about the work that they're doing or guide any sort of discussion about what's going on in the world of indigent defense research.
You can
at our
just
meeting,
Yep.
and I will remind folks that if you're not speaking, you should mute yourselves. And if you're not able to do that quickly, we actually do have someone here in the meeting who will mute people if we do hear loud noises continue. But happy to have such a great crowd here. And yeah, just wanted to make sure we shared that reminder. So today we have two of our board members, Marea and Claire. I'll let them actually introduce themselves in a moment here, but they're going to be speaking about Gideon at 60, a snapshot of state public defense systems and paths to system reform, a report that they both worked on. So I will leave it to them to give the full context and to introduce themselves. But again, thank you all for being here, and I'm really looking forward to today's talk.
All right. Thank you, Stephen. And yeah, we're really happy to see all of you today and to speak with you about this report. I'm Marea Beeman. I'm an independent consultant who works on projects to improve public defense systems. And
I'm Claire Buetow. I'm also a public defense consultant. I do work with the National Association of Public Defense and the Decent Center, but this is a separate project that we worked on together last year.
Yeah.
And Maria, I'll go ahead and share the presentation if you want to get started.
Okay, really cool. Thank you. Claire is operating the slides because I'm not very good at it. So yes, Stephen said, yeah, our report is, this is the report, Gideon at 60, a snapshot of public defense systems and paths to reform. And we created it at the request of NIJ and the Office for Access to Justice to commemorate the 60th anniversary of Gideon versus Wainwright. And I just want to say here that I can't think of any other court opinion or state and local justice system function that gets a birthday celebration by DOJ agencies. You know, not probation, not courts, not police. So we're really grateful to DOJ for the awareness it brought to public defense last year, and in particular to NIJ and ATJ for their support in producing this report, which came out in November. Now, if we took a snapshot of state systems today, it would look a little bit different. Some positive changes have occurred since our research for the project ended in July. And we'll talk about those briefly, but we still feel the value has value. We feel like the report still has some value and relevance. And so we wanted to share a little bit about it with you. Next slide, please. So our roadmap is that we're going to run through the purpose of the report, the methodology, our findings, and some key takeaways. And after we run through the slides, if anyone's up for it, we'd love to open up a little discussion. Next slide, please. So everyone here knows, I think, that 61 years ago in Gideon versus Wainwright, the Supreme Court decided that the Sixth Amendment to the Constitution requires states to supply defense counsel to anyone accused of a felony if they can't afford to hire a lawyer. That right was extended to apply to all crimes where an individual faces a loss of liberty. So it was really Gideon that spawned the creation of our current state and local public defense system. Next slide. The purpose of the report is to present a national scan of public defense models currently used for adult trial level criminal cases in US state, local, and tribal jurisdictions. It's not about juvenile systems, it's not about appellate systems, and it's not about federal courts. It's aimed at a broad audience. Our methodology was limited to review of publicly available materials, including reports, law review articles, and government websites. That was supplemented by interviews with 17 subject matter experts who came from a spectrum of national, state, and local stakeholder groups. And we reached out to many others to help us fact and spot check information. We extend our extreme gratitude to all of those we interviewed and who helped us with that fact checking. And our hope is that this report complements more rigorous statistical surveys like those the Bureau of Justice Statistics undertakes and other program evaluations of public defense systems. So Claire's going to walk you through some of our key findings.
Thank you, Maria. This is the first of 3 chapters. In this chapter, we're talking about the models that states use to provide public defense. So there's many different ways to think about public defense models. We used 4 variables, which were delivery methods, administration, funding, and oversight. We wanted something relatively simple for policymakers to understand, and we wanted to use what's used in other national surveys, especially from the Sixth Amendment Center. We looked at systems only for adult criminal, non-capital trial level cases, and we focused on state versus local responsibility for those functions because we wanted to focus on how Gideon made public defense a state responsibility and look at how states have complied with that. And because a lot of the major recent reforms that we are talking about have to do with shifting responsibility to states. So again, this is research that wrapped up in July of 2023. Some of what I'm about to show you has changed, but this is a snapshot of that time. So for each variable, we looked at existing 50 state surveys, did some of our own fact checking, and I'll give you a quick look at each of our national maps. First, we looked at states' delivery methods. We looked at what their primary delivery methods are, and by that we mean if there was a method that they used in more than 75% of their public defense cases, roughly. That data is not available from a lot of places, so we had to use some of our best estimates sometimes. And we also looked at E. Primus's work, which was a great reference for this area. Also, when we say private assigned counsel, we're grouping together their contracts, max, a few different types of models, again, in the interest of keeping these definitions pretty short and simple. So we found that while all states now use some combination of methods, 20 states primarily use public defenders, 5 primarily use private assigned counsel, and the rest use more of an even mix of the 2. This is overviews of administration and funding by state. Administration is basically who is selecting and appointing lawyers. Funding who is ultimately paying for them. Most often states have mixed responsibility for administration and funding. Just to note here, we included municipal cases. So compared to some other national surveys, we have more states in the mixed categories because some of those state systems don't cover municipal cases. Finally, for oversight, we analyze whether states have a commission or other entity that sets standards and monitors delivery methods. Some states have a commission that's limited in which types of cases it oversees or what enforcement powers it has. And the key finding of the report was only about 1/3 of states have full statewide oversight of public defense. And we think that's important because in theory, under Gideon, states could delegate administration or funding duties to local governments, but they still need to have oversight of whether the systems are following the Constitution. But most states don't know what's going on with public defense in all cases. I also want to add here that we used a lot of Sixth Amendment Center reporting for this section, and they have since launched this amazing website that has these types of maps with lots more detail and profiles and news updates from all the states. So anyone who hasn't taken a look at that yet should.
Where are these from?
Gideon Lloyd. He's one of my not competent but restorable guys.
I
He was
think
on house
someone
arrest.
needs to go on mute. Okay, the next slide here, this is an overview where we are overlaying all 4 of our variables. Oversights on the left, administration and funding are at the top. States are color-coded by their delivery methods, and they're underlined if they've had major reforms recently, which we talk about a little bit later in the report. If you go from the top left of the chart to the bottom right, you're seeing more state involvement in public defense. And as you'd expect, state administration and funding tend to go together. But there's also some states that have a pretty large role in funding public defense and yet don't have total oversight of what they're funding. Next in this chapter, we describe constitutional requirements for models and common issues that states run into with those requirements, model practices, and how to meet them. We use the ABA 10 principles as a guide, which has since been revised, but is still consistent with what we're talking about here. For independence, we note widespread conflicts of interest in who runs public defense. We note that diverse boards of directors and elected public defenders are ways to protect independence. We note that more states are now ensuring prompt appointment of counsel, especially at the first appearance or even sooner. We cover the administrative burdens and fees that often come with applying for counsel and how some states have simplified those requirements. And finally, we cover how effective representation has been hindered by negative performance incentives, especially from low flat fee contracts, staffing shortages and high workloads, and a culture of burnout. So we describe states' efforts to alleviate those issues and public defenders' shifts toward more client-centered, holistic defense models and systemic advocacy. Finally, in this section, we note that Gideon does not apply to tribal courts, and American Indians and tribal courts do not have a right to court-appointed counsel, though some non-Indians and tribal courts do. Still, many tribes have opted to provide public defense using similar methods as the states. In chapter 2, we describe how the performance of public defense is measured. This is something that I think this group is pretty familiar with, so I'll just touch on it briefly. We asked experts to identify core goals for public defense and the best way to measure progress towards those goals. And the measures that we talk about can be grouped into 2 areas: access to counsel and quality of counsel. Access being, in what portion of cases do people receive any type of lawyer? Also, how often can states even track how many public defense cases they have, which is shockingly infrequently, according to at least one report. And quality of counsel being, the quality of services provided, especially with caseloads being a key measure of that. We also talk about forthcoming research about public defense, particularly the surveys and census coming out from the Bureau of Justice Statistics about public defenders, and research on the effectiveness of some of these states getting more involved in public defense delivery. And now I'm going to hand it back over to Mari to talk about chapter 3.
Okay, great. Thanks. And yeah, there was a question in the chat if we'll put the link up to the report. Absolutely. I'm just not going to do it now.
Every year. They can't give you no 5-year set off. They can't give you a 3-year.
Yeah, I don't want to lose my spot on the screen. But we will get you the link for sure. So I'm going to talk a little bit about our reforming models findings. So basically we set out to analyze factors that contributed to strengthening defender models. Next slide. So this is an excerpt of a matrix of 12 states that experienced changes in the past decade. Whether the changes included creating a new state oversight entity or increasing state funding or changing delivery models, 3 factors, litigation, research, and advocacy, were key ingredients of reform. And arguably, research is the single most important factor, or rather, it's the foundational factor for any change. The next slide. We also profiled 3 states, Michigan, New York, and Georgia, that have experienced substantial changes. Most, but not all, were for the best. We gave particular attention to Michigan, whose progress really stands out, and it serves as a terrific model for other states contemplating reform. In 2013, Michigan shifted from a locally run, locally funded model to having state oversight and state funding. The state now covers 80%, and maybe a little bit more than that, of costs. The now decade-old Indigent Defense Commission sets standards and distributes funding. Local governments create plans to meet the state standards. Due to the importance of home rule in Michigan, incremental implementation and collaboration between state and local players have been central to Michigan's steady push forward. We also highlighted some backsliding that happened in Georgia. Unfortunately, backsliding is always a possibility. So just like we learned from the Michigans and the New Yorks, we can learn from the Georgias. In brief, in 2003, Georgia experienced significant advances in state oversight, delivery system, and funding. But flaws in the structure and the funding mechanism left it vulnerable to political pressure. And sure enough, in 2015, some of the initial reforms were rolled back. Next slide. The report touches on other factors beyond those seen in Michigan and New York that can accelerate reform, including centering client and community voices in reform campaigns and in defender organizations, resourcing defenders proportionately to other criminal legal agencies, securing federal funding to incentivize state standards compliance. We note that federal support has been helpful, specifically research like BJS's Census and Public Defender Survey projects, advocacy like DOJ's Dear Colleague letters, and litigation. The Office for Access to Justice and the Civil Rights Division have issued statements of interest in adult and juvenile matters, and the Civil Rights Division has used its investigative authority in juvenile cases. Advocates urge the Civil Rights Division to use that authority in adult cases as well. Next slide. So here we start our conclusion. I just like to pause because I like looking at Brendan there. But anyway, let's advance to the next slide. So some of our takeaways are that under Gideon, the buck stops with states. It's not counties or localities. States are responsible for providing public defense. Most states, though, have just partial oversight of public defense, and many systems have built-in conflicts of interest. The lack of oversight and independence has led to widespread lack of counsel or quality deficits, i.e. counsel, providing counsel in name only. State level standards, oversight, and funding are essential to reform. Research, litigation, and advocacy have been essential drivers of state reforms. And again, research undergirds litigation and advocacy efforts. Systematically tracking data about access to and quality of counsel is essential to monitoring whether Gideon's promise is being delivered. Federal DOJ agency support plays an important role in encouraging reform in state and local public defense. BJS, BJA, ATJ, CRT, NIJ, they all participate in this, and we encourage the continuation and expansion of that federal support. Specifically, we believe that the investigative authority Civil Rights Division has in juvenile cases should be explicitly expanded to adult cases. And we've seen the importance of standards plus funding in state reform. So we believe the federal government should set out minimum standards and offer funding as incentive for states to comply with them. Finally, no state interested in strengthening public defense needs to start from scratch or wait until it's sued. Resources such as the ABA 10 principles and the National Workload Standards Study offer valuable roadmaps. So next slide. That's basically the quick overview of what's in the report. We encourage you to look at it. We will post it. We put that in the chat. I know you can't really link from a slide. But yeah, feel free to contact us with any questions. Also, there's just a ton more information in the report. It's really detailed. It has lots of examples. So next slide. we do want to mention, as we said, some of the key resources that came out after the report was published, or after we finished our research for the report. And notably, we now have the national workload standards and the updated ABA 10 principles. I had my props, here they are. ABA 10 principles, you can get a new copy. You can get this cool cover if you contact Sployd, they have them, it's great. So I just want to say that the 10 principles now contains a principle on data collection and transparency that directs states and public defense programs to collect, review, and act on data about public defense. Yeah, so this is a meaningful expansion that I'm hoping is persuasive for building out in-house research, defender research capacity, and for supporting more rigorous research. The Sixth Amendment Center, as Claire mentioned, introduced its new website with interactive maps, and Ben Polk produced his rigorous estimate of just how much funding is needed to produce provide constitutionally sufficient public defense services across the entire country. And then some of the notable system changes that have occurred since July. South Dakota introduced first time ever state involvement with a new commission, some state funding, and a new appellate public defender. Similarly to South Dakota, Pennsylvania has introduced some state funding to support localities. Louisiana went backwards. The legislature stripped the oversight board's independence. Oregon began on a path toward use of more state employees, i.e. public defenders, under its newly instituted commission. And Minnesota secured long overdue pay increases for defenders to help reduce backlogs. Okay, so next slide, please. We just wanted to, we're happy to answer any questions anyone has about all of this, but we also are, we're happy to launch into a discussion because we have a question for this community, this research community in particular. So going back to this ABA Principle 4 on data collection and transparency, the text is up there. And we want to ask you as a research community, how or can we use this standard to advance our work? And I'm going to toss out 1.5, which is around Oregon. So Oregon was long touted as having an exemplary state-funded system that used flat fee contracts. And they're, otherwise we all know that that's a no-no model, right? As the primary delivery model. Well, eventually research trickled out that showed this assumption was flawed. Fewer and fewer attorneys were participating, which led to waiting lists for counsel. The state commission imploded and was reconstituted. In short, it has been a mess, and it's going to take years to fully clean it up. But a key problem was that contractors weren't required to report on services delivered, how contract money was used, or even on which attorneys were participating or delivering services. And arguably, if the state administrative office was tracking contractor performance data, it would have picked up on these problems and headed off the crisis that erupted. So maybe that's an extreme and simplified example, but I'm just really wondering if others have any thoughts on this, how we could maybe use this. Paul, I see your hand, Paul. Please just unmute yourself and go ahead and talk.
Yeah, I guess I for one, I actually do agree that I think that your example is a perfect one in the regards of if we had some more public data, we might have been able to catch it sooner. But I think the other thing that we're dealing with on the reverse side is we're a little concerned about what the state may do with some of this data. For example, we had a county who realized all of a sudden that the contract lawyers were slightly cheaper than the public defenders. And that's probably because they used really poor funded flat rates and had contract lawyers who, well, I shouldn't comment on what the contract lawyers did or didn't do. I won't comment on their quality. I am also, we only pay hourly in our county, but what happened was they actually closed the public defender's office based upon that data. And so right now in defense, we're sort of, before ABA published this Principle 4, I really was against a statewide defense data system because I felt like it could be in a Republican state used against us. And since this, I've really been reflecting a lot. I spend a lot of time reflecting about what is this, and then this happened in a rural county where they closed the public defender's office and then went with these lawyers in a way that I'm very frightened for the defense in that community. But so I guess it's not really a thought as much as like the sword swings both ways, I guess, and I am very much trying to find myself in the middle. But I just wanted to bring that up as a sort of, you know, my hesitancy, but at the same point, I do agree that there's good reasons for this. So that was it.
Yeah, no, I think that's yeah, there's always two sides to every story, and I totally agree with you. There is a danger of the data being misused. I guess that always exists too. So I guess I still have kind of the same question though, like if that's the case, then how do we lean into the standard that it's important? I mean, I just think personally, we're a part of this community. We probably have similar opinions that the data and research are critical to advancing public defense services. But yeah, we don't want it to be used against us for sure. I don't know if anybody here has other examples of where that's happened. Jean Faria, I see you're on. I don't know if you know what happened in Louisiana, if, for instance, research could have possibly held off, you know, really a very political climate that the state was in for the recent kind of rollbacks there of independence, or if anyone else has any other thoughts on, you know, how far can we go with research saving the day or helping. But I mean, I think Paul's comments are really valid. Anybody else have any thoughts on this or on anything else? Well, I'm hearing crickets, so okay.
I was. Oh, do I have sound?
Yes. Hi, Tori.
Okay, great. Sorry. I just wanted to contribute, just to continue on that tack, something that has come up in Indiana, where so as your report correctly indicates, we don't have a very good defense data infrastructure, and I do think it's improving. But if nothing else, I do think the access to information would help us, even though I do think there is, like, you know, we do have people in the state that could potentially use it against us. But in the current state, like it, and I don't know if this is common elsewhere, but like the prosecutorial side does have pretty good state level data, and but they're very stingy about it. They don't give it to anyone else, and so it only gets deployed when it is useful for their purposes. Which, I mean, you know, we're extending the adversarial system to to state level data. That's not particularly surprising, but you know, if nothing else, we can have people like in this community that can kind of combat those decisions with our own data, right? So if we don't have this good data infrastructure for defense, then we're in trouble if other people can bring data to bear that we can't. And then if that data is available to everyone, at least it's an equal playing field, which I feel like it often is not. I definitely do. I hear Paul's point, but I do think that we generally have more to gain than we do to lose. And I also wouldn't be surprised if, you know, as many things in politics, maybe that office was going to close regardless, and they were looking for a reason. But Paul would definitely be able to speak to that more than I would. But yeah, so all that is to say, I definitely do think, coming from the back foot, as so many defense organizations are, I think we have a lot more room to grow than we do to lose by increasing the data infrastructure. And then I will.
Well, thank you for that, Torrin. I think that's really, it is worthy of mention to say, well, prosecutors have a certain amount of data and the defense may be operating with less information. That is always going to be a problem too. Jean, do you want to chime in here?
Yeah, a little bit. Hi, Maria. You know, in Louisiana, I will say that when we first started the state system in 2007, had it not been for a real push to get accurate data, we never would have grown the budget as much as we were able to before this very unfortunate. It's not just the loss of the oversight, but it's also the shift in the whole structure of the public defender system now. But we would never have been able to grow the essentially $30 million and keep it without that data constantly pushing to keep data. So I don't know how you make these strides, and I don't know how you know what you're really looking at and where you need to spend your time and energy and resources unless you have available, accurate data. It just makes all the difference in the world, you know, and I can say that as the first state public defender in Louisiana.
Yeah, I appreciate that, Jean. It has just been, it's been a struggle in Louisiana, but back and forth, so.
It always is.
Paul, did you have, you had your hand raised?
Well, I mean, you know, I agree with Torrin that it's a possibility that the public defense didn't manage their relationships with the board in that particular county very well. I will say I recall when the AVA released the 10 principles, there was a comment somewhere, because I think the principle number 4 definitely talks most specifically about funding and adequate workloads. But I feel like somewhere else in the comments, there was also a comment on just the fact that without that data, it was a missing element to the criminal justice system's process. And I remember that it was talking also about ensuring, and maybe it was the report to the general AVA committee, but it was also talking about that the reason for this data would be to also ensure that they were meeting, public defense was meeting all the rest of the principles. So I do think that from that standpoint, you know, workloads and funding is an important aspect of it, but I also wonder a little bit too about in trying to sort of come into like in support of this, and I do agree with Torrin's point as well that, you know, if we're not there, then you know, our side isn't being told. And I think that the other principles include, you know, eligibility and the fines and fees, and I think that that's something that is not being tracked very well. And as Jean said, you had to have good data, and I think that we're one of those people who could say, here's how many people and what they make. The courts do a really terrible job at reporting the data from their financial assessments, and not that we really, in my opinion, we really should be involved in the financial assessment of our clients, but that at least tracking what was the final numbers and what was the fees attached to that, so that there is that data available. And then I also think too, one of the things that I still am hopeful at some point to work with the Decent Institute to the Decent Center to study this, but is also that early access. And one of the things that we want to do a study on is really, we have in our system when we meet with our clients and when their hearings are, and really doing the study to how often those things are. And so I think that those are another thing that could come into it. But then also I think about experience and training, and are we tracking how much training they're getting and comparing that to training the county attorneys or the prosecutors are getting. And so I do think that in trying to get into alignment with this, that's where I kind of go back to, is that in the comments in the report, it was not just about funding and workloads, but also about the rest of the principles and whether we're meeting them. And so that's where we have an opportunity, as Torrin said, to really gain more than lose. I mean, I think also most defense agencies are poorly underfunded. I think in some conservative states, I won't say politically, some fiscally conservative states, they may not care as much. But anyway, so I just wanted to add that point to it all as well, is that I think the rest of the principles should be tracked, looking at how are we measuring those principles in our data. Anyway, that's what I was going to add.
Yeah, thank you. I mean, that just, again, just kind of makes the point that you need to measure kind of everything or have data on everything. And someone put in the chat a question of like, well, what kinds of data do we track? What are we talking about here? And I think you just ran through a lot of the data points, Paul, that are valuable to have. And expanded that to kind of the realm of fines and fees and early access. Defenders may not have access to all of that information, but they can track what they're responsible for. But I just think that, again, with this particular principle, it's highlighted here. It says states should track. So it's not just the defender programs themselves. I mean, I think that we can be using this principle as ammunition to say, look, it's bigger than just an individual defender program. We need this information from the court system. We need all the system players cooperating, because this is important stuff. That's just my hobby horse opinion, but I agree with you. We need all that stuff about fines and fees and early access, because it's so critical to the quality of representation and the things that people are saddled with as they go through life after a case is adjudicated. Anybody else have any thoughts on any of this? I do not want to be talking over others. Okay, well, we really appreciate your attention here today, and your participation, I think, is really good for us to hear thoughts about this. And I'm sure we will keep thinking about it as we go forward. And we encourage you to get the report and check out some of the examples. We have hard copies of our report. If anybody's interested, Claire and I have a big box of this, and Venmo us the postage, and we'll send you as many as you want. Otherwise, it's online. The link is in there. So, anything else, Claire, that you can think of?
No, thanks for having us, everybody.
Yeah, thanks everybody. Thanks for tuning in. See you next time.